Tony works at a Target distribution center in Joliet. He tore his rotator cuff moving inventory 6 weeks ago. His wife has been pushing him to file a workers' comp claim in Illinois, but Tony will not do it. Every time she brings it up, he says the same thing. If I file, they'll find a reason to let me go. He's seen it happen to guys at his facility. What Tony does not know is that Illinois law specifically makes what he is afraid of illegal. I'm Mark Connolly, a Chicago workers' comp attorney, and if you're afraid to file because of what your boss might do, this video is for you. Let me give you the direct answer first, and then we'll get into the details. No, your employer cannot legally fire you for filing a workers' comp claim in Illinois. Illinois courts have recognized what is called retaliatory discharge. It's a legal claim you can bring in circuit court if your employer fires you specifically because you exercise your workers' comp rights. The Illinois Supreme Court established this case called Kelsay versus Motorola. If your employer fires you, demotes you, cuts your hours, or makes your job situation miserable, specifically because you filed or were thinking about filing a workers' comp claim, that is against the law. Now, let me be honest with you about why the picture is more complicated than that one sentence may sound. What retaliatory discharge actually means under Illinois law. Illinois courts have recognized retaliatory discharge as a separate cause of action, meaning you can sue your employer for it independently of your workers' comp claim. The standard under Illinois law is that if a motivating reason for your termination was your workers' comp claim or your exercise of rights under the Workers' Comp Act, you have a retaliatory discharge claim. You do not have to prove it was the only reason. You have to show it was a reason. The remedies for a successful retaliatory discharge case in Illinois include reinstatement, back pay, and in some cases, compensatory damages. These are real financial consequences for employers who violate this protection. The law has teeth. Why workers are still afraid and why that fear is understandable. I'm not going to stand here and tell you the fear is irrational, because the reality is more complicated than the law on paper. Employers who want to get rid of someone after a workers' comp filing usually do not send a memo that says you're fired because you filed. They find another reason. They document attendance issues. They write up performance problems that were never written up before. They eliminate a position. They reconstruct a department using cost reduction initiative. If they do it right, the timing looks coincidental. Your claim was filed 3 months ago. The layoff happened last week. Hard to prove, even when everyone on the floor knows exactly what happened. So yes, the fear is real. The legal protection is also real. But the gap between law as written and what some employers actually do in practice is real too. That is why what you do before and immediately after this matters so much. What to do to protect yourself before and after you file. Document everything. Start before you file. What does your job performance look like on paper? Do you have positive performance reviews? Do you show up on time? Have you received any written discipline? If your employer tries to build a case against you after you file, your prior record is the foundation of their story. If your record is clean, that works in your favor. Make sure it's documented. After you file, keep records of everything. Every conversation with your supervisor about the injury or claim. Every interaction with HR. If anyone says anything to you about the claim, write down what they said, who said it, the date and time. If you receive a written warning after years of clean performance, keep it. If the hours change on your schedule get modified, document that. Timing is your friend in a retaliation case. If you file on Monday and receive your first ever written warning on Thursday, that sequence tells a story. Courts and arbitrators at the Illinois Workers' Compensation Commission see these patterns. The key is that you have documented the timeline clearly and contemporaneously. What happens if your employer offers you light duty that's not really light duty? This comes up all the time. After filing, an employer might suddenly offer a modified duty position. The job they offer may not actually fit within your medical restrictions. It might require heavy lifting, standing, or movement that your doctor has restricted. And if you refuse it, the employer can argue you're refusing available work. Don't refuse any modified duty position without talking to an attorney first. The decision about whether offered work genuinely fits within your restrictions is a legal and medical question. Get counsel before you respond. What if you have already been fired? If you've been terminated after filing a workers' comp claim, you may have a retaliatory discharge case. Retaliatory discharge is filed in circuit court, not at the IWCC. The general window to bring that claim is 5 years from the date of discharge. Contact an attorney as soon as possible if this already happened to you. The sooner you document what occurred, identify witness, and preserve evidence, the stronger your position. Memories fade. Former coworkers move on and become harder to reach. Evidence gets stale. Do not wait. For the spouses and partners watching this, if your husband or wife is sitting at home hurting, not filing because they're afraid of losing their job, I understand. The fear comes from somewhere real. They have probably seen people get pushed out. They are not being irrational. But their hesitation is costing your family money every single day. The wages lost, the medical bills piling up, the uncertainty about what comes next, all of it gets worse the longer they wait. And the fear of retaliation, while real, does not mean retaliation will happen. What it means is that they need to go in prepared. An employer who fires a worker for filing workers' comp is exposing themselves to a separate lawsuit with real consequences. That matters. It does not eliminate the risk, but it changes the calculation. The practical advice that most attorneys skip: before you file anything, have a conversation with your attorney about the specific dynamics at your employer. Are there layoffs happening? Has there been recent turnover? Has anyone else at your workplace filed recently and faced consequences? All of that context informs strategy. Filing a workers' comp claim in Illinois is your legal right. The protection against retaliation is real, but going in with a plan, documenting your standing as a good employee before you file, reporting the injury in writing immediately, and knowing who to call if something happens afterward, that is what separates the workers who get protected from the ones who get hurt twice. If you've already filed and received an IME notice, or if your claim has been denied, watch the videos on this channel covering both of those situations. They'll walk you through exactly what to do next. Subscribe to stay current on everything we're publishing about Illinois workers' comp rights. And if you want to talk through a specific situation, Connolly and Law is here. Free consultation, no pressure.